Today, Republican Congressman Chris Collins introduced the Second Amendment Guarantee Act, or Saga. Now, it would limit states' authority when it comes to regulating rifles and shotguns, not handguns. If the bill passes, most of the language included in the SAFE Act would be void, and that's also true for any other state that has tough anti-gun laws.
Tonight, 2 on Your Side's Kelly Dudzik is getting answers from a legal expert about the constitutionality of this proposed law. Kelly.
Adam and Mary Alice, earlier tonight I spoke with a UB law professor via Skype about this legislation and the potential challenges it could face in the future.
Congressman Chris Collins spoke with gun clubs in Monroe and Erie County Monday to unveil his new legislation, which would prevent states from passing laws restricting Second Amendment rights when it comes to rifles and shotguns. And with little chance of the New York State Legislature repealing the SAFE Act.
This legislation would declare null and void the SAFE Act as it applies to rifles and shotguns used by sportsmen and hunters. And
Collins told reporters he's confident he can find enough support in the House.
I don't think that's going to be difficult at all, because a lot of Democrats also are sportsmen, they are hunters.
And Collins sees a clear path forward.
There is no judicial dispute when the federal government passes such a law. It does preempt state law.
Joining me now is Rick Sue. He's a professor at the UB Law School. Rick, what was your initial reaction when you read this proposed legislation?
I was a little shocked. It's a very broad law, very extensive. I know the Congressman has talked about it primarily with regard to the New York SAFE Act, but the extended law would essentially preempt all gun registration laws, all gun-related laws throughout the country.
So what kind of constitutional challenges could this face?
The courts have often said that the federal government is a government of limited powers, and that when they go too far in regulating certain areas without a specific constitutional grant of authority, that's beyond their powers. It looks like this particular bill is trying to say that the federal government can preempt state firearm regulations because of the Commerce Clause. The question for the court is this really about interstate commerce, or is this really about a policy question with regard to domestic criminal law issues?
What kind of chance does this have even getting through the House at this point?
It would effectively preempt all state laws, any regulation, any registration, regardless of what it's about, concealed carry, open carry, this and that. And I wouldn't be surprised if a lot of congressmen would find that their states would not want their particular laws about who can possess a firearm, for example, even in red states, from being preempted by federal power.
All right, Professor Sue, thank you so much for joining us tonight.
Thank you. It's a pleasure.
Back to you.